Good afternoon to you. So we will continue with Constitution. Today, Judiciary, last part, that is Article 129 of the Constitution. This is the powers of the Judiciary to punish for contempt. We have seen in the last class Article 142 as well as Article 143. As you know, Article 142 empowers the Supreme Court to pass such orders as is necessary for doing complete justice in the matter before it. Such orders are enforceable throughout the country in the same manner as may be prescribed under the law of the Parliament. I gave you an example of banning triple talaq. Under Article 142, Supreme Court banned the triple talaq, and as a necessity, as a sequence, Parliament has to make a law banning triple talaq. Similarly, the relief to Bhopal gas victims was also ordered by the Supreme Court under Article 142 of the Constitution. These are all two important examples. Under Article 143 of the Constitution, I told you the President of India can seek the opinion of the Supreme Court on any matter which involves a question of law or question of fact which have arisen already or which is likely to arise, and the Supreme Court may tender its advice, which is of course not binding on the President. In respect of those matters referred to under proviso of Article 131, the Supreme Court is bound to give its opinion. In other cases, it is not bound. I have already discussed this in detail in the last class. Today we will see another most important power of the Supreme Court, that is the powers of the Supreme Court to punish for contempt under Article 129 of the Constitution. Article 129 of the Constitution makes the Supreme Court a court of record. What does it mean? Court of record, and confers all powers of such court, including the power to punish for contempt. First of all, we should know what is a court of record. Court of record is a court whose records are admitted to be of evidentiary value and are kept in a perpetual memory, and they cannot be questioned when they are produced before the court. Right from 28th January 1950, all the decisions, all the proceedings of the Supreme Court are kept in a perpetual memory, and each decision of the Supreme Court has evidentiary value, and such a decision, such judgments are once produced, no other argument, no further argument, because if the facts are same, no further argument. Whatever decision has been given by the Supreme Court will ipso facto apply to other cases also. Now, once a court is declared as court of record, its powers to punish for contempt automatically follow from the position. The powers to punish for contempt has been expressly conferred on the Supreme Court by the Constitution itself. It is not as a result of any act. It is in the Constitution itself, Article 129. It is the extraordinary powers with the Supreme Court, of course, which should be used sparingly by the Supreme Court. Now, there is an act to follow up. There is an act, Contempt of Court Act 1971. This act has not defined what exactly constitutes contempt of court. However, this act has defined the powers of the court to punish for contempt, and also the procedure for punishing it. Both, what are the powers, what is the procedure to be adopted? Both these things have been explained in Contempt of Court Act 1971. The Act provides two types of contempt of court. One is civil contempt and the other is criminal contempt. What is meant by civil contempt? Very simple. If you do not obey the orders of the court, it is civil contempt. Remember, what is civil contempt? Willful disobedience to any judgment, decree, direction, order, writ, or any process of the court. This is civil contempt. Or willful violation of any breach of order or breach of promise given to the court. I have given a promise to the court. If I am not able to keep it up, it is civil contempt. There is an order for the court to appear before the court on such and such date. If I do not appear, it is a civil contempt. Very simple to remember. Criminal contempt, the other one, slightly difficult. What is it? It is very simple again. Publication, either by words or written or any means, including Twitter, any means, of any matter or doing any act which lowers the authority of the court, or which interferes with any judicial proceedings, lowers the authority of the court, or which interferes with any judicial proceeding, or which obstructs the administration of justice. These three, that is, which lowers the authority, which interferes with the judicial proceeding, or which obstructs the administration of justice. These three constitute criminal contempt. Remember, first one civil contempt, the other one criminal contempt. The contempt of court applies to judiciary also. Remember, judicial people are not excluded from the purview of contempt of court. Contempt of court, the provisions of Contempt of Court 1971 equally applies to judiciary also. That is, a judge or a magistrate or a judicial officer, any person acting judicially shall be liable for contempt of his court or any other court as any other individual is liable. It applies equally. Second point you should remember. And what is the punishment? A contempt of court is punished with a simple imprisonment up to 6 months or fine up to 2,000 or both. How much? 6 months SI, simple imprisonment, or 2,000 fine or both. This is the punishment. Now, under contempt of court, even a minister or an official can be held guilty of contempt when the contempt of court is committed by the state. The state might have committed, but the personal responsibility, vicarious responsibility lies on the minister. For example, you may recall that no less a person than the Chief Minister of Uttar Pradesh, Kalyan Singh, was punished with a token sentence of 1 day imprisonment and a fine of rupees 2,000 for breach of his promise given to the Supreme Court and National Integration Council by his failure to prevent construction work at Ayodhya by the sadhus in Ram Janma Bhoomi case. This is a glaring example how the contempt of court can be issued, extended not only to ordinary person, even the chief minister of the state. And as recently as July 2020, senior advocate of the Supreme Court, Prashant Bhushan, was issued notice of contempt for 2 tweets made by him against the judiciary. One was aiming at Chief Justice of India, another aimed at judiciary. Supreme Court took cognizance suo motu of 2 tweets and issued notice to the senior advocate. The next hearing is, of course, scheduled in 5th August 2020. Supreme Court held that on Article 129, the Supreme Court has powers to punish a person for contempt of court, not only itself, but also its subordinate court. So remember, even though Article 29 applies, the contempt of court powers applies only to Supreme Court and High Court, but extends to other courts also, which will be taken by the High Court, which will be taken up by the High Court or Supreme Court. So, Supreme Court has powers to punish a person for contempt of court, not only of itself, but also its contempt for all subordinate judiciary. Okay. Now we are coming to the last part of judiciary, that is the powers of the Supreme Court to exercise judicial review. Very important powers. What is judicial review? It is the power of the Supreme Court to examine the constitutionality or otherwise of any legislative enactments or executive powers of both central government and state government. These judicial review powers have been given to the Supreme Court under Article 13 of the Constitution. What Article 13(2) says, 13(2) says that the state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. Part 3 is fundamental right. If any law is made taking away or abridging any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy, is null and void. Remember, the state is defined to include central legislature, state legislatures, central executive, state executives, local body, or any authority which is functioning under any of these organizations, any of these institutions. Law includes ordinance, act, regulation, instruction, orders, directions, writs, custom, or usage which has the force of law. So, who will decide this? The Supreme Court. So, the state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. If any law is made taking away, abridging any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy, is null and void. So, if the legislative enactments or executive orders are violative of the provisions of the Constitution, they can be declared unconstitutional. National Judicial Commission, Appointment Commission, declared unconstitutional. Abolition of Privy Purses, original, declared unconstitutional. So, we have seen so many cases, we have Ramesh Tappar cases we have seen Shankari Prasad case, we have seen Shanbagam Rajan case, we have seen Golaknath case, we have seen what is known as Kesavananda Varadi case, we have seen Minerva Mill case, We have seen Vamana Rao case. In all these cases, Supreme Court exercised the Article 113 powers and made null and void of any of the some provisions of the amendments. So they can be declared unconstitutional if they violate fundamental rights or any provision of the Constitution. Now, there are three circumstances which warrant judicial review. Three circumstances. What are those? Number one, what is the purpose? To uphold the supremacy of Constitution. Number one. To maintain federal equilibrium. Number two. Number three, to protect fundamental rights. Similarly, the constitutional validity can be challenged on three specific grounds. Remember, number one, infringement of fundamental rights. Number two, it is outside the legislative competence of the Parliament. Number three, it is repugnant to the provisions of the Constitution. So, we have seen this. Now, remember, if you make a comparison with the judicial review in USA and in India, US constitutional judicial review is wider than Indian judicial review. In spite of the fact that we have made a specific provision in the Constitution itself for enabling judicial review. On the other hand, there is no express provision in US Constitution to enable judicial review. Nevertheless, three words, due process of law. Due process of law is different from a procedure established by law. We have already seen under Article 21 of the Constitution. No person shall be deprived of his life or personal liberty except by a procedure established by law. I have told you in the first case, what is A.K. Gopalan versus Union of India. Then subsequently Maneka Gandhi versus Union of India. So, procedure established by law is, there should be a law passed by legitimate legislature, and that law should provide a procedure, and that procedure should be followed for depriving a person of his life or personal liberty. That's all. The judiciary will not go above these things. So, in A.K. Gopalan case, his freedom was curtailed. No person shall be deprived of his life or personal liberty except by a procedure established by law. So, his liberty was curtailed, and the law was Defence of India rules. So, under Defence of India rules, the rule was made as a result of the law, preventive detention law. So, the procedure given in the Defence of India rules have been followed before depriving Mr. Gopalan of his life, of his liberty. So, that is valid. That's all. Whether that law has provided a procedure, that procedure is correct, whether no person should be condemned without hearing, no person can sit on judgment on his own decision, and every person is innocent until and unless otherwise is proved. These jurisprudence principles have been followed. That is not the question of judiciary. Judiciary will see whether there is a law, if there is a law, that law has provided a procedure. If the procedure has been provided, that procedure has been followed before curtailing the freedom. That's all. Beyond these questions, judiciary will not go. On the other hand, in due process of law, everything will be examined. Whether the law was passed with any motive, whether the law has a purpose and the provisions of the law have nexus, whether due process, whether the jurisprudence principle has been observed, all these things will be seen in the case of due process of law. So, that due process of law is not available in Indian Constitution, whereas instead we have only a procedure established by law. So, they have a wider judicial review process than Indian Constitution. With this, we will end the judiciary now. We will switch over to center-state relations tomorrow. Thank you.